Hi, my name is Merrill Cohen. I'm an immigration lawyer practicing in New York City for about 20 years now, almost all immigration, business immigration. And in the past 5 or more years, we've been practicing heavily in the P-1, O-1, EB-1 category for athletes of extraordinary ability and international acclaim. We'll be speaking about that visa today, the P-1 in particular, and only as relates to athletes. That a P-1 also is a visa that's used for entertainers and other situations, but we're limiting the talk today to athletes and who qualifies, and in case the client does not qualify, what alternatives you can seek for them, as well as whether they could apply for green cards and in what categories. So we'll begin by saying the P-1 is for athletes who are competing in tournaments in the U.S., either individually or as part of groups or teams. The events that they're going to compete in must be international level, and when they come here, they must have already acquired international success. The success does not have to have been in more than one country. National success is fine as long as it's internationally recognized. And at the regulations, which are at 8 CFR Section P regarding athletes, right away it starts off with an interesting point, which is that the alien must have an intent not to leave their home abroad. But at the end of the same regulations, it actually says that a permanent residence petition filed for that athlete cannot be the basis for denying an extension of stay or an admission in P-1 status. So what we advise our clients is to always show home ties, especially if they're at the consulate and they don't have a permanent residence petition pending for them. So that's just something off the bat. I'll try to throw in many practice points along the way, so we're not just running through the regulations. To continue, the athlete must demonstrate national and international success. We'll go through the type of documentation immigration typically wants to see that would confirm that to them, and the athlete may have more than one employer. They're allowed to work for an agent or through a sponsor or for one employer. Typically, the way we're filing these cases, it's for an agent that represents more than one employer, and then the alien can work not just for them, but for these other employers, so long as they present contracts. And just as a practice point, the Vermont Service Center is, we're finding, just like many courts have different interpretations of the law, the Vermont Service Center seems to be very lenient with regard to who can sponsor the alien. So if you have a choice between who's going to sponsor the alien, whether it's going to be someone out west or on the East Coast, from our experience, you're going to be better off filing with an East Coast sponsor, even if some of the employers are, throughout the country. That's the status as of now in August 2014 and what we've seen over the past 5 years. Maybe other practitioners have different experience, but I haven't heard of it.